Hey, before we get into this one, just a heads up. What you're about to hear is going to sound small at first. A judge, a ruling, some legal language. Stay with me for the next 2 minutes because by the end of this video, you'll understand why 3 separate federal courts just told the President of the United States, in 3 separate rulings, in the span of about a week, that he does not have the power he's been telling the country he has, and why that fight is now colliding with a second story about redacted files, a convicted sex offender, and a woman's sworn allegation against the man currently sitting in the Oval Office. 2 stories, 1 thread. Let's pull on it. Here's where most coverage starts and stops. A federal judge ruled this week that the Constitution does not give the president specific power over how elections are run in America. That's the headline. It sounds procedural. It is not procedural. What actually happened is that a sitting president tried to build a federal system to decide, ballot by ballot, whose vote counts. And the courts, for the 3rd time in 8 days, said no. To understand why that matters, you have to understand what he was actually trying to build, because voter ID is the friendly name for something considerably bigger. Picture the system as it's worked for 2.5 centuries. States run elections. They set the rules, print the ballots, count the votes, certify the results. The federal government, including the president, has historically had almost no role in that machinery, by design, because the framers were specifically afraid of concentrating that kind of power in one office. What the administration proposed was a federally compiled list of confirmed citizens, built using Social Security data, with the Postal Service instructed to cross-check mail ballots against that list, and to refuse delivery in states that didn't comply. Strip away the branding, and what you're left with is the executive branch holding a master list that determines which ballots even reach a count. That's not an adjustment to the process. That's the process being relocated into the West Wing. 3 judges looked at that and ruled it illegal in less than 2 weeks. U.S. District Judge Judges Talwani in Massachusetts blocked the administration from compiling that national voter database at all, ruling flatly that neither the executive nor the legislative branch has the authority to build one die. That power, she wrote, belongs to the states alone. Days later, Judge Casper, in the same federal courthouse in Boston, went further and made an earlier temporary block permanent. Her language was almost contemptuous of the administration's own justification. She noted there was no evidence in the record of the widespread fraud the executive order claimed to be solving. 0, not thin evidence, none. And she wrote the sentence that should genuinely worry anyone tracking how far a president can push. The Constitution does not grant the president any specific powers over elections. Now, normally, that's where a story like this ends. Court loses, administration appeals, news cycle moves on. Except the administration's own response tells you this isn't actually about courtroom procedure. It's about whether the president accepts losing it all. Because rather than quietly absorbing the ruling, the president used a primetime setting the same night to restate, almost word for word, the exact policy 3 judges had just told him he couldn't legally pursue. Proof of citizenship. No mail-in ballots except for illness, disability, or military service. And then, and this is the part that matters, he pointed at California, where ballots were still being counted weeks after Election Day, and said, on camera, they're cheating. Not, the system is slow. Not, I disagree with the rules. Cheating. With no court finding, no investigation, no evidence, just the accusation, live. Hours after a federal judge had just ruled, there was no evidence of exactly that. That's the long-short rhythm of what's actually happening here. The courts keep ruling on facts. The president keeps responding with assertion. And the gap between those 2 things is where the real story about America right now actually lives. So, if the courts keep blocking this, why does the administration keep going? Here's the uncomfortable answer. Because losing in court was never really the obstacle. The real obstacle is Congress, specifically a 60-vote threshold in the Senate that the president's own party doesn't have the numbers to clear. The legislative version of this same push is called the Save America Act, and it would do through statute what the executive order tried to do through decree. Require documentary proof of citizenship to register, require photo ID, and effectively end no-excuse mail-in voting nationwide. The House passed a version of it. The Senate has tried to pass it. twice dollars by attaching it to unrelated budget bills, and twice it died because Republican senators including Susan Collins, Lisa Murkowski, Mitch McConnell, and Tom Tillis crossed over and voted with Democrats to kill it, twice, from his own party. And here's the number that should genuinely stop you for a second. Independent research cited in this fight estimates that more than 21 million otherwise eligible American voters do not have easy access to the specific documents, birth certificates, passports, naturalization papers, that this law would require them to produce just to stay registered. 21 million. That's larger than the population of most countries on Earth. Supporters call this election integrity. Critics call it the largest voter disenfranchisement mechanism proposed in modern American history. Both descriptions are talking about the same 21 million people. They just disagree on whether that's a feature or a catastrophe. When the legislative path stalled, the president didn't pivot to a new strategy. He escalated the existing one. He publicly threatened to refuse to sign a bipartisan housing affordability bill, a bill with support from members of his own party, until Congress passed his voter legislation first. Housing costs, held hostage to an election bill that doesn't have the votes. When you start asking what a president is willing to sacrifice to get a policy passed, you usually learn more about that policy than any press release will tell you. Now here's where this story turns into something else entirely. Because at almost exactly the same moment these election rulings were landing, a second federal judge issued a ruling involving the president directly, and this one isn't about elections at all. U.S. District Judge Sullivan ordered the Department of Justice to release additional unredacted files connected to Jeffrey Epstein or explain under oath by name why it legally cannot. This case began when journalist Katie Fawing sued the DOJ, arguing it was violating a law Congress had already passed, the Epstein Files Transparency Act, which required the release of these documents months earlier by a deadline the department had already missed. What makes this ruling unusual isn't just that the government lost, it's how it lost. The Justice Department, given the chance to argue in court that it was actually complying with the law, didn't make that argument. It simply didn't respond. And Judge Sullivan said exactly that in his written opinion, that the Attorney General had effectively conceded the violation by failing to substantively contest it. Among the specific materials the judge ordered released, documents identifying alleged co-conspirators whose names had been blacked out, email chains where senders and recipients were obscured, and, this is the part that connects directly back to the president, the underlying FBI interview notes behind a woman's account that, as a teenager in the 1980s, she was introduced to the president by Epstein and was sexually assaulted by him. To be precise about what the ruling does and doesn't establish, this is a transparency order about access to documents, not a criminal finding, not a verdict, and not proof of guilt. The president has denied any wrongdoing related to Epstein, and has said the two men had a falling out years before any of the alleged conduct described in these files. What the ruling does establish, in the judge's own words, is that the government's own legal defense for withholding this material collapsed when tested in court. So, look at what's actually sitting next to each other in the same news cycle. One court says the president doesn't have the authority he claimed over how Americans vote. Another court says the Justice Department doesn't have the legal justification it claimed for keeping documents hidden. Documents that include an allegation against that same president. Different judges, different legal theories, different government agencies. Same underlying pattern, an administration asserting a power or a justification, and a federal court, applying ordinary, unglamorous legal procedure, taking it away because the legal basis simply wasn't there. That pattern is the actual story here, not one ruling, not one news cycle. A pattern repeating across separate institutions in the same 8-day window, each time landing on the same conclusion. The claim exceeded the authority. Whether that pattern holds is now mostly a question of timing, and which court gets there first. The election case is moving towards circuit courts that have, so far, been skeptical of this kind of executive overreach. But the Supreme Court is a different and considerably less predictable venue, especially heading into a midterm election where control of Congress is directly on the table. The Epstein case has a hard deadline, July 2nd, for the Justice Department to either comply or justify, under oath, exactly why it won't. Both of those dates are coming, whether anyone is ready for them or not. What happens after that is the part nobody currently gets to script. That's it for this one. If you want to understand where American power actually sits right now, you don't watch the press conferences. You watch which arguments survive in front of a judge and which ones quietly don't.